like Mr. Fisher said.
I don't believe it. I don't believe it. You weren't picked up until March 11th, over a month. Don't be giving me some story about you wanted to save up that $1,000. That's blarney. That's a story. That's made up. Baloney right now. I don't believe you. You know what a warrant is? It's either you pay the cash, you turn your butt into jail. That's what you do.
Today, we've got an entitled brat who thinks the court is a joke and a warrant is just optional. This man has been strolling around like he's on vacation while the entire court system is out looking for him for over a month. He genuinely believed he could wander free, clock into work, live his life, and somehow the warrant would just magically expire like a parking ticket. The judge is already irritated, and you can feel the tension the second he opens his mouth. Nothing says bad idea like trying to negotiate with the court after ignoring it for weeks. And he still can't figure out why nobody is impressed with his excuses. Do you think the judge is about to show sympathy for that? Let's go ahead and dive in.
We have Mr. Butkus Taft appearing by video conferencing in custody in Burnett County Jail. We have Zachary Fisher, defense counsel, also by video. We're set today in this matter for a status conference. Mr. Fisher, please update the court.
Your Honor, Mr. Butkus Taft was picked up on the warrant after he missed the last status conference, as his reason was not an emergency. I did discuss this with Mr. Butkus Taft, and he does understand ultimately that it was entirely his fault and that he, regardless of other outstanding obligations, needed to make sure that this was his first and most important obligation due to the seriousness of these allegations and ultimately that this is a court-ordered request. And it's not a request, it's a court order. He was very apologetic, and if you would like him to make a statement, I am not opposed to him making one today. I will just say that we are ready to resolve this case. We would be ready to schedule this for a plea and sentencing if Mr. Butkus Taft was to have his bond amended either to a signature bond or to have his signature bond reinstated, or if his cash was reduced. Ultimately, Mr. Butkus Taft was working before he was arrested. I'm hoping that that job is still available because ultimately I know the money is going to ultimately go towards this restitution that he needs to save up for and pay. And I just hope that he would be able to go back to the community, make sure he keeps working, saving up money for this restitution, because our goal, I believe, will that he prepay quite a large amount. I don't have a specific amount on me right now. I believe it's somewhere in the ballpark.
11,000 something, 11,700 and something, I believe.
Yes, and I believe we were looking at prepaying at least about 2,000 was our goal that we were planning for. So my hope would be that with some time, if he was released from custody, he would be able to save up some money, and then we would be able to come to an agreement that would resolve these matters and benefit Mr. Taft as well as the victims in these matters. So for those reasons, I would request that the signature bond be reinstated, and or that if there is concern for flight risk for the missed court appearance, I would ask that a lower cash bond be imposed.
Mr. Butkus Taft, why weren't you in court?
Your Honor, like my attorney said, I take full responsibility for it, but it was an honest mistake. I had my outpatient treatment group until 10 a.m. that day, and just lost track of time. My kids were home from school that day, and they had conferences that my wife was going to go to, so I just started helping them get ready, lost track of time, and it was unintentional, but it was all my responsibility to make that court date, and I didn't, so just lost track of time, Your Honor.
Are we in victims' rights compliance for a modification request?
Yes, Your Honor, I did contact the victim.
Ms. Rockow?
I might have missed this, but did he turn himself in or was he arrested on the warrant?
He was picked up in Marin. I believe he was picked up, correct? You didn't go and turn yourself in, and you were picked up. When were you? Explain that to me. When did you find out you had a warrant? You should have found out right away. And,
I did find out. I'm sorry to interrupt you, Your Honor.
Go ahead.
I did find out right away. I guess just my train of thought was I'm the only one working, my family. In hindsight 2020, because now I've missed more work than I probably would have if I turned myself in, but I just wanted to keep going to work and then pay that the $1,000 cash bond.
$11,000 in restitution? Yeah, he better start saving nickels, pennies, birthday money, because that bill isn't disappearing. And his excuse for missing court? I just lost track of time. Lost track of time? This isn't forgetting to move laundry to the dryer. This is a literal court date with a pending warrant attached. Judges don't schedule hearings like dentist appointments. You don't just show up late with a Starbucks and call it even. When you're staring at possible jail time, that hearing becomes the most important thing on your entire calendar, even above breathing. And if you can't make it, there's this thing called calling the court. Not exactly advanced technology. But no, he just decided working his job was more important. As if a warrant works on your schedule and respects your work hours. That's not how custody works. You don't handpick your arrest time like a restaurant reservation. The judge is sitting there listening to this circus of excuses, and you can literally see her patience evaporating in real time. Every sentence out of his mouth makes the bond go higher in her head. And if you're wondering whether this ends well for him, it absolutely does not.
It would have taken longer to save up that amount of money than I've sat in jail for this warrant, so, No, I should have turned myself in right away, but, yeah, I was aware of the warrant. I just wanted to keep going to work. I didn't plan on, like being on the run for a long time or anything. I wanted to pay that cash bond so we could move forward with this case. Like Mr. Fisher said.
I don't believe it. I don't believe it.
Okay.
Your hearing was on February 6th. You knew you had a warrant.
I know.
You weren't picked up until March 11th, over a month. Don't be giving me some story about you wanted to save up that $1,000. That's blarney. That's a story. That's made up. You could have turned yourself in and you could have said right there, just as your attorney's doing right now, could have said, you know what, Judge, I messed up. You know what, Judge, this is what happened. You know what, Judge, I was in outpatient treatment. My class ran late. I have kids. I was taking care of the kids and I needed to get them to conferences. I was being a dad and doing all those things. You could have done that and you could have done what you're doing now and asking to have your bond reduced at that time. Baloney. Baloney right now. I don't believe you. So in fact, I'm raising bail to $2,000. $2,000 cash bail. Now, that's what it's going to be. So you can figure out how to bail yourself out for $2,000 because I don't believe it. You had from February 6th, 2025 until March 11th, 2025 to figure it out, to turn yourself in, to have your attorney ask the court for leniency like you're doing now. But you didn't. You didn't. And now you're sitting in court and you're whining and crying and you're saying, but this is a long time I've sat, 7 days. Judge, it's been 7 days I'm sitting in court and now I don't know what to do. You should have thought about that on February 6th. You should have thought about that on February 7th. You should have thought about that on February 8th or 9th or 10th or 11th or 12th or 13th, 14th, 15th, 16th or so on. You should have thought about that. But now you are because you are in jail. Now's when you're thinking about it. You don't get to have hindsight is 2020. Hindsight's 2020 for everyone. If we all could say, you know what? I should have, would have, could have. We all should have, would have, could have. And now you can't. So now you got to figure out how to come up with $2,000.
Your Honor, may I add something?
You may.
I understand why Your Honor is frustrated, and I'm not going to discuss whether or not the amount of time he was in warrant status was appropriate or not. What I will say is that he did contact me within, I don't know the exact time frame, but I can say at least 2 hours of the hearing, trying to essentially appear either that day or as soon as possible. And I believe you denied that request because it wasn't an emergency at the time.
Do you know what? Because you want to know what this court says? I didn't deny the request, Mr. Fisher. You know what a warrant is? It's either you pay the cash, you turn your butt into jail. That's what you do. And if he didn't have the cash, he could have went to the jail and said, you know what? Here I am. take me. Here I am. I'm turning myself in, and then go to the mercy of the court. That's what people do. So I don't want to hear that excuse either, Mr. Fisher. He called you within 2 hours. Good, great, wonderful. It's awesome he called you, but he did nothing after that. He could have turned himself in that day, and then, Mr. Fisher, you could have done what your job is, what you did, and filed a bond motion, and this court could have said, you know what, Mr. Butkus-Taft, I understand. I get what you were doing. I get the predicament you were in that day and that you had a little bit of oversight and time and you made a mistake. But over a month is not a mistake. It's not a mistake. It's absconding. It's purposely avoiding the law. It's purposely avoiding a court's order. It's purposely having criminal thinking. When we have criminal thinking for 4 criminal charges with over $11,000 in restitution that's allegedly owed. So he may have done the right thing by calling you within a couple hours, but he did a lot of wrong things after that.
I understand, Your
So
Honor.
let's get a status conference in so we can figure out if this thing's going to be figured out. But I'm guessing that there needs to be a prepayment of some restitution if this thing resolves.
Yes, Your Honor. That was the idea, is that we didn't have the specifics as to whether or not what the terms of the plea would be or what charges specifically, but we were and are currently prepared to stipulate to the restitution being requested, and that was the only remaining issue we had in this case. So we were going to request a plea and sentencing date, but obviously now with his custody status, maybe it would be best if the bond is going to be $2,000 to set a status either at the end of this week or next week. To see
I think a status would be a good idea. This is D.A. Schmidt's file, but
Oh, well, I'm glad to know that because I was looking for your week.
thank you.
April 10th, 9:30.
Could we do earlier?
Actually, you're here April 7th at 10:45, or you're here at March 27th at 10.
If I could appear by Zoom on April 7th at 11, we could potentially have a resolution at that point.
Oh, wait, April 7th, not at 11, you may not. I have a motion hearing at 11
I apologize.
at
Do you have-
10:45.
I can do that then. That works. That's when I have the status on the other case.
April 7 at 10:45. That's what I do. I stack my statuses because they should only take a couple seconds unless there's a lot to argue.
Yes, Your Honor.
But he had well over a month to turn himself in and simply didn't. Then he sat in front of a judge and tried the sad story, please feel bad for me strategy like the court was handing out sympathy coupons. We all knew exactly how this was going to go. The judge didn't buy a single ounce of it, and instead of lowering his bond, she doubled it without blinking. And honestly, that's fair. You can't play cat and mouse with the court system, like it's a game of tag, and then pretend to be shocked when the judge hits you with reality. He had every chance to do the right thing and chose the opposite every single time. Judges aren't unaware. They've heard every excuse since the dawn of time, and his wasn't even original. You play stupid games, you get expensive bonds. And the courtroom is the very last place you want to run a personal hide-and-seek tournament. Do you think defendants should get harsher penalties when they dodge warrants, or should judges offer second chances no matter what? Let me know down in the comments. Thank you so much for watching. Don't forget to like and subscribe, and I'll catch you in the next one.